Imagine your personal data being sold without your explicit consent. A scary thought, right? Sling TV is facing a hefty penalty for allegedly making it difficult for users, especially parents of young children, to protect their privacy. They're settling a lawsuit with California for a cool $530,000, but this is just the tip of the iceberg, as California investigates multiple streaming services. At the heart of the issue is the California Consumer Privacy Act, CCPA, a landmark law designed to give you more control over your personal information. Think of it as your digital bill of rights. The CCPA mandates that companies provide an easy way for consumers to opt out of the sale of their data and to know exactly how their data is collected, used, and shared. But here's where it gets controversial. Some companies, like Sling TV, allegedly weren't making it so easy. Sling TV, owned by Dish Network, has agreed to streamline its opt-out process and provide clearer disclosures and tools for parents to minimize the collection and use of their children's data. A spokesperson for Sling TV stated, "We are pleased to reach a resolution with the California Department of Justice, DOJ, and have implemented privacy enhancements to address the DOJ's concerns. While we disagree with certain characterizations, Sling remains committed to respecting the privacy rights of its customers." This sounds good on paper, but what exactly were these characterizations they disagreed with, and what privacy enhancements are being implemented? This lack of detail can be frustrating for consumers. The lawsuit, filed in California State Court, claims that Sling TV deceptively directed users seeking to opt out to its cookie preference controls. And this is the part most people miss. Cookies are just one way companies track and share your data. The lawsuit alleges that even after turning off cookies, Sling TV was still selling and sharing personal information. To truly opt out, users had to navigate a labyrinth of hard-to-find links and fill out a web form. Adding insult to injury, Sling TV didn't offer an opt-out method within its apps. Instead, users had to type a long URL into a separate browser and jump through even more hoops. The CCPA is clear. Businesses must provide a simple mechanism for opting out, like a setting in the app's menu. Think of using a smart TV. People should be able to go into the settings of the Sling TV app and simply select, "Do not sell my personal information." Furthermore, unlike many other streaming services, Sling TV didn't offer parental controls to limit targeted advertising for children. They didn't have a kid's profile that would, by default, block the collection of personal information, age screen users, or obtain parental consent. The settlement now requires Sling TV to create at least one user profile specifically for kids that does not collect personal information as the default setting. This is a crucial step in protecting children's privacy online. California Attorney General Rob Bonta emphasized the importance of these privacy rights, stating, "Our investigative sweep looked at all the different ways consumers should be able to stop the sale of their data when using streaming services. We take privacy rights seriously, and Sling TV was not providing consumers an easy way to opt out of the sale of their personal data as required." This settlement with Sling TV is a warning shot to other streaming services. Expect more investigations and potential lawsuits as California cracks down on companies that violate the CCPA. But the big question is this enough? Will these changes truly protect consumers' privacy, or are they just a band-aid on a much larger problem? What are your thoughts on this settlement? Do you think other streaming services are adequately protecting your data? Sound off in the comments below.